Welcome to Whistleblower Network News, Whistleblower of the Week. I am your host, Jane Turner, an FBI whistleblower and whistleblower advocate.
Okay, bye-bye.
Bye-bye.
And when you're all grown up, I think you'll find that it's just as hard to stand up tall as it was when you were small. The truth is hard to say.
Welcome to Whistleblower of the Week, and we have on someone today who is a giant in the field of government waste, fraud, and abuse. For over 25 years, Dean Zerbe was active in congressional investigations of government waste, fraud, and abuse. He left Congress in 2008, where his last position was as senior counsel and tax counsel on the Senate Finance Committee for Senator Charles Grassley. Dean also served as Senator Grassley's chief investigative counsel on the Finance Committee for several years prior to being appointed senior counsel. Dean is widely recognized by the press as a leader in tax and oversight matters. He has appeared on CBS Evening News and has been quoted in numerous publications, including the New York Times, the Wall Street Journal, the Washington Post, and so on and so on and so on, as well as specialty publications such as Tax Notes and The Practical Accountant. In addition, Dean is a columnist for Forbes magazine online. Dean, it is a pleasure to have you on today. Not only are you a hero and an advocate for whistleblowers, but you have been successful in implementing policy with Congress. So you are a big deal. And I welcome you. I welcome you. Tell us what's going on in the tax world.
You bet, Jane. Well, thanks so much for that introduction, and wonderful to be here with you. Just it's such a great opportunity, and thanks for all the listeners here too. Just glad you're tuning in, and yeah, let's talk about that. I think spend a fair amount of time talking about the tax whistleblower program, which I wrote for Grassley when I was on the Finance Committee. As we all know, or I think many of your listeners know, Grassley's been the longtime champion of the False Claims Act. So that's kind of the bedrock or the cornerstone of all these whistleblower award programs. And that's really something that Grassley, with his amendments that he did in 1986, I think it was, really modernized and brought to the world. It was the old Lincoln laws, but he brought it in there. The one part of the False Claims Act that isn't covered, though, is tax. So in other words, you couldn't get an award for tax under the False Claims Act. You could get an award under kind of a very old and cold, actually, interesting enough, Jane, a program that also went back to about 1867, that you could get an award for blowing the whistle on tax. But it was a very kind of catch as catch can program. It was discretionary. It was really pretty small amounts. And kind of was being run out of a shoebox by the IRS. It just really wasn't a robust, serious program when we looked at it. So when I was on the Finance Committee, Grassley wanted us to look at this. And as you know, Jane, it's not untypical. So many government agencies have these award programs that really aren't effective, really don't do a number, and what have you, be it FDIC or something like that. And so we looked at it. And it's a separate law, separate from the False Claims Act, but we went ahead and passed the statute under Grassley's leadership. It's under Section 7623 of the tax code. And that made a big change. It did kind of three big things, I'd say. One, it made it mandatory. It's a shall pay. You shall pay the whistleblower. Essentially, if three criteria are met. One, to give information to the government uses that information, and it results in collected proceeds, meaning they've gotten dollars in, and it's and all the appeals rights, everything's been settled. In other words, they're not going to have to give the money back. So if you meet those three criteria, and then you can get between 15 and 30%. That was another key part of the statute. So basically, roughly similar to the False Claims Act, the architecture. And then lastly, that you had a right to go to court to appeal your award. Probably the big difference with the False Claims Act is that it doesn't allow for you to file your own lawsuit. And the False Claims Act, you can bring your own case in and say, these rascals aren't doing it right and they need to pay. A couple of states have since kind of piggybacked, and they do have state False Claims Act for tax. New York is one. DC actually passed one the other day. So there's a little bit of that, but still for the federal level, it's just still kind of that you go to the IRS and you convince them that your claim is meritorious. And a lot of work that I do now, we've had good success with that, helping and working with Steve Cohn, of course, who's very involved with the National Whistleblower Center, as you know, too, but have gotten a number of clients, hundreds of millions of dollars in awards since then. So that's kind of the program in a nutshell. The IRS is pretty good at, I shouldn't say pretty good, they're quite good at keeping the whistleblower anonymous, meaning that while you have to provide your name to the IRS will not reveal that they have a whistleblower to the taxpayer. And I find they're quite good at protecting the identity. In other words, if you give them a document, they're not going to kind of come running in with it and say, hey, what about this document? And in a sense, kind of revealing that there's a whistleblower. So I think they do a good job on it. There's an office now. We created an office with this. This statute goes back to 2006 now, so it's been in place for a number of years, but really is just now beginning to hit cylinders. It's had pretty good support, regardless of the administration and regardless of who's the commissioner. And that support, I think, has gone up and up, really, since there's been more and more recognition of the value of whistleblowers. I would say when we first passed it, in fact, I know, we were kind of, to take a Grassley phrase, kind of the skunk at the picnic. People just really didn't think that, they thought this was all, a hill of beans and, really not something. But quite frankly, probably what started the turnaround was Brad Birkenfeld, client of mine and client of Steve Cohn's, who ultimately got an award of $104 million.
Yes.
He really broke open the banks, as the song says, he busted the banks of Monte Carlo. He busted the Swiss banks in Swiss bank secrecy and got hundreds of millions of dollars coming into the federal government. The government, to their credit, particularly when Janet Yellen came in, the current secretary who's about to leave, they absolutely recognize the value of the whistleblower program, particularly in that area of the offshore accounts. So it's taken a long time, and Jane, you know better than I do. It took a long time for the False Claims Act to kind of get acceptance, and I don't think we're quite there yet. But they've grown the office considerably. It's now going from, it was usually like 20 people. Now it's 80 people at the IRS they're saying it's going to grow to 120 people. We'll see. Obviously, there's going to be some tension there. But I think that the program's doing well in that regard. We still have changes in the law that need to be made and some responses to court cases, which we'll talk about. But I do think that we're in a things are going in the right direction and are promising. But I've talked a lot there, Jane. Let you fire away with some more questions.
No, this is fascinating, and this is part of this introduction I gave you, is that you are just an incredible individual who has fashioned these programs, and so I don't think there's anyone who has more knowledge of the tax system than you. I mean, this is just incredible. But tell me why the tax whistleblower system is different from the false claims one, because I don't think our listeners, they kind of get, it kind of gets mixed up. But why isn't it all under the same umbrella? Why does the tax have to be different?
Yeah, it's a good question. We ask that a lot ourselves sometimes. Yeah, tax very much likes to view itself as different.
Oh, yeah.
When we first did it, just trying to amend it was kind of an odd thing. We actually had in 7623, the code section I mentioned, you had now what is 7623A, you had this kind of rump of a traditional program. Like I said, the one that was discretionary, that was kind of being run, out of a shoebox and what have you. Sadly, I remember talking to the woman who ran it, that most of it involved discussions with prisoners, and we were unhappy spouses, and we were pretty wide-eyed because we had just done an investigation on Enron, and you can remember that. And I would tell you, the keys to the kingdom for us in that investigation was a whistleblower who came in and said, "Yeah, fellas, let me explain to you what's going on here. We never would have figured out, in 1,000 years what Enron was doing,
Oh, yeah.
but for that whistleblower." And it's, because they were designing to hide, designing to obfuscate what was going on. And, he's the kind of fellow that could say, "Well, what you need to do is look at, page 87 of this 300-page document and see this footnote. Yeah, that's in there." And, you get the idea and you're like, "Oh, well, wow." And so
Right.
that's what you really so often in tax need, is somebody that is going to get through all that. And so that really brought it home to us on a bipartisan basis. I should say that we passed the law, while, all hats off to Grassley. Then
Right.
ranking member Baucus, the Democrat counterpart, was very much hand in glove on this. And Senator Wyden has since been very supportive of Grassley in these efforts as well, too. So it's been a very bipartisan effort, and we've gotten good support on the House side now, too. But so going back to your good question, when we looked at changing the statute, we had a statute in place, and there were some parts of that that were fine, and it was going to be too difficult. And this is going to get very arcane inside baseball for your listeners, but it's a good
Yeah.
reason why do things happen the way they do. For us to, in the finance committee, we did not have jurisdiction, and Grassley was chairman of the finance committee at that time, which meant he was, he was the man. He was chairman of the finance committee at that time and had jurisdiction over, obviously, the tax code. We did not have, even though he was number two, I think, on judiciary at the time, he was not the chairman of the Judiciary Committee. And the False Claims Act comes under the Judiciary Committee. So it was very much a jurisdictional issue, and that it would be much harder for us, kind of thinking like home field advantage. Maybe that's the easiest way for your listeners.
Oh,
If you're the Packers, I think you want to play at home. If you're trying to get something changed, you want to be at home. You want to do it in your committee's jurisdiction. There's not nearly as much, what are we doing here? Why is this happening? But as the chairman, at the end of the day, it was a kind of a small provision in a bigger bill, and it took us a couple of years to get it through. Even for the chairman, it's difficult to just say, okay, make it happen. We had to kind of convince the folks, and quite frankly, get a vehicle that moves. But it was a lot easier to do all that if he's because he controls the legislation and what have you, makes it a lot simpler journey comparatively, I should say, to getting a provision through. And then what happened is we ultimately were able to attach it. Unlike folks who, you can remember your basic civics, or you watch the old cartoon of, I'm a bill on Capitol Hill. You really don't move much legislation all by itself. As I kind of liken, like Star Wars, we need to get attached and, float along with the rest of the garbage. We need to, you need to be part of a much bigger bill. And so happily, that's what happened. But you're, again, kind of the point, you're able to manage and deal with when those big bills are moving, to say, aha, here's we go. And the nice thing is it was scored as a revenue raiser, which again is very inside baseball. But once the Joint Committee on Tax agreed with us, albeit they said it was going to raise much less than it ultimately has, it brought in billions. They said it was going to raise in the millions. But even that small amount kind of made it so much easier for us, because we're always looking for revenue raisers and ways to offset costs and offset things.
oh
So
yeah.
once that happened, everyone was like, sure, we'll take it. No one, we're not going to object. And away you went. So that really made sense. But that's why it wasn't on the False Claims Act, and why we didn't do the easier thing. And I would say to you too, Jane, now you've kind of got my mind opening it. It was
Yeah.
a big deal just to get this moving. The tax community is, very small,
Oh,
conservative, very, change is always questionable. And to say, well, yes, you're going to be able to go to court for somebody and challenge their taxes, was just a world that they couldn't imagine seeing. So it was also our best way to do it. And it's kind of proven a model that worked. So you had the False Claims Act. We then passed this one where more you have to convince the agency, and it's not, perfect. But in some ways, as we know, a lot of the False Claims Act is yes, you file, but then you're spending all your time not trying to convince the Department of Justice to take the case. So it's not that different. Oh, and I should add too, one nice thing about the IRS version versus the False Claims Act is, in the False Claims Act, you really have kind of heightened standard. You got to show, not just that they did something wrong, but they were evil or bad, or thinking bad thoughts when they did it. I don't need to show that in tax. I just needed to show they owed tax. I don't need to show they were bad guys and knowingly did this or
oh,
recklessly did this. I just need to show I don't care if they innocently did it, they owe tax. And so that makes it a much easier burden to prove for a whistleblower there. But that model, Jane, for your listeners of kind of coming to the agency, albeit still with a mandatory award, if you meet certain requirements and a judicial review, was then the model then for, and in part because Grassley uses the model for the SEC whistleblower program and the CFTC whistleblower programs are again kind of similar. That they're separate statutes. They're not part of the False Claims Act. They're part of that. So that was kind of a lot of the reasons that it drove us to go this path as opposed to the False Claims Act and away you go. But you'll find when you look at it, there's a lot of similarities. I mean, a good example is, in fact, it's actually better than the False Claims Act. For instance, it's absolutely expected or anticipated that we're going to get angels with dirty faces coming in. In other words, particularly in tax, in other words, in the False Claims Act, you can get people who maybe, hey, I was working in loading, or I had a case where it was really administrative assistant who said, geez, they're billing the government for 10 boxes, but they're only sending 5 boxes, that kind of something. Tax is so complicated. I'd be honest, even I, as a tax attorney, I need someone to say, well, tell me again, what is it you think that they did here? You really need that insider to walk you through, not always, but in so many cases, here's what's happening, here's what's going on. And so we recognize that because of the Enron situation, that we didn't want to have a situation where we would be essentially barring the folks that we most wanted to talk to, or the IRS hear from, who were insiders. So the thresholds of being able to get an award are more friendly. There's probably the best word, friendlier to the whistleblowers. And if you're Madoff, you're not going to get an award. But as long as you didn't plan and initiate something, it's very common. We'll have somebody that says, yes, they asked me to, do this transaction, or I helped with this transaction. Very common who we have coming in, and the IRS has no problems with that. So it's in some ways it's an improvement on the False Claims Act, and that's a good example of it. So but we've still got a ways to go. The one thing that they haven't picked up, and then I apologize, I'll get back to your good questions, but it suddenly occurred to me, is that we're still getting them being the IRS to work more with the whistleblower, meaning in the False Claims Act, they're much, much better. You file, and then I get the sense it's much more hand in glove of, hey, tell me about this, or we want you to get this, or you can interview these people. And that's great. It's saving the government resources. For the IRS, if it's a criminal investigation, they sometimes, they'll have the person wear a wire, or they'll do something. I mean, there'll be some discussion with the whistleblower and some interaction with the attorneys. But on the civil side, they still haven't really met that. In other words, it's kind of more of a fire and forget. You'll file, and that's where we'll talk more about what makes for a good filing and how to do a good filing. But it's kind of, you get your filing, they'll maybe interview you once, and it might be as long as a half day. But that's kind of it. And you've obviously got the documents you provided, but there's not this kind of give and take of, well, hey, the taxpayer said X, what's your answer to that? Well, that's for the birds. And that's too bad, because that's really the value. I just think some of my clients, I think of even like Brad Bergenfeld, just do the Swiss banking system like nobody's business. I just said, fellas, you paid him $104 million. You should just chain Brad to a desk and, have him working day and no, but it gets just so bad. It's just so difficult, if you could think about it, Jane, to convey everything. Think if you've worked 20 years someplace, to say, let me tell you everything that I know. And it can be as mundane as, well, why has it got this check on the, it's got that check because that means, blah, 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 and what have you. So anyways, it's still growing. And like I said, opportunities for the new administration to I think build on that, but go ahead, Jane. What other?
No, this is just so fascinating. I can't believe it. I want to out you, Dean. You are the true architect of the Whistleblower Office at the IRS. You cannot deny that. And you also are instrumental in a lot of the legislation that passes on taxes and whistleblowing. And so you're a phenomenal person. Let's not kid ourselves. And initially, what was amazing is you had a background in film. which I don't know how that plays into what you're doing now. Changing the world is what you're doing. But I think we should point that out because it's pretty
That's right.
amazing.
Yes, I'm the
Yeah.
only person who has a film degree from NYU. I had that when I was a very young man, and then I had no family in the film industry, and that turned out that might have been helpful. But I don't think the world's weeping that they have not seen my films, or that they never came to fruition. But right, and then I left that and then came down to Washington, went to law school at night at George Mason, and then actually went back up and got my what we call an LLM, kind of an advanced law degree in tax from
Oh,
NYU again. So I'm the only person from NYU who both has a film degree and a LLM in tax law from NYU. So yeah, it's a rare world,
pretty
small
impressive.
world.
Yes, pretty impressive. And I also have to point out to make sure that we're clear here, you also helped me tremendously in my fight with the FBI, and I can never thank you enough for that. It was just phenomenal. How
Well, I
how
think credit to John Drake. I think was
he was
John.
there.
Yeah, he was terrific on all that. Yeah, so
Yeah,
hats off to
but
him. Yeah.
I will never forget you. And John Drake. Let me ask you, how did you get such a close relationship to Senator Grassley? How did that happen?
You
What
know,
were you doing?
that's a good question. I came to the Hill as a very young man. I left college early. I
Hmm.
graduated then, and I was very fortunate to get an internship and then a job as a legislative correspondent, which is kind of the entry level for a fellow named Congressman Denny Smith, a Republican out of Oregon, fifth district, kind of the Salem area, if you will, now. And he was a very, kind of like so many members. He's moved on. He was there for about 10 years. He was very unappreciated congressman. Now, I was reading his Wikipedia piece. I was like, geez, this doesn't really do him justice. He was a fighter pilot in Vietnam, and he came in
Oh,
with Reagan. He'd actually defeated the then chairman of the Ways and Means Committee, a guy named Al Ullman. So it was a big upset that he beat him. So he came in with Reagan. And I think early on, like I said, he was certainly a strong conservative and stayed that way. But he got very interested in military reform and making sure that the weapons worked and that we got good bang for our buck and that our troops got weapons that would, protect them or serve them and everything like that. And so I played a small part of his efforts. It's really where I started to cut my teeth in oversight was with him. Well, on the Senate side, Chuck Grassley, Senator Grassley hadn't been in the military. I think an ag deferment because he was too old rather for any of the wars. But he was always a fellow that counted the pennies for the taxpayer, all from his days back in Iowa in the legislature, and then came to Congress in '74. I think one of like new Republicans elected in the Watergate class for the Republicans. But he was very staunch on that, and then he got connected with really the grandfather of all the whistleblowers, Ernie Fitzgerald.
yeah.
And so the great Ernie Fitzgerald, who was the guy who Nixon tried to fire, who saw the overruns on the C5 and everything like that, he connected with him and a investigator of his, who of course did a lot of the FBI work, as you know, Chris Kolesnik, and
Yes.
really did sort of so kind of a long story. He got involved in the costs involved with defense and that side of it, as opposed to the hardware, the military, the guns, do they fire right kind of a thing, which was more Denny's side. But they made a good team in terms of their work, and really the Military Reform Caucus played a big role in that. And so I got to know Grassley and Chris Kolesnik from that. And I'll never forget the first
Wow.
time I met him. I think of it now that Grassley was younger than I am now. I'm always kind of, time moves along. This is 1985, I think, now by the time I show up. And there he comes in, and Grassley has big gumboot shoes. And I'm sitting at this table, and he comes in there and he puts his big gumboot shoes right next to me. And, I'm just a little snorky. But, here's a U.S. senator, and he
Hmm.
was as affable and kind as he could be. And he just was kind of listening. I forget what we were there for, but he just kind of got to chatting. But knew him from that, and then just stayed in touch with him in the office for years. We did a lot of work together. I went and served in the Army, just really as a reservist, but did all that. Anyways, long story, came back. I was in the Bush administration, Bush 1, at the Pentagon, and then over at HHS, actually in refugee resettlement, back when refugee resettlement was a
Oh,
forgotten corner of the world, and now everybody
yeah.
knows about refugee resettlement.
Right.
It's a different world. But
Yes.
anyways, and then I came back and worked for Grassley. And I worked for Grassley on and off for like 4 times running. And then the last run, I was actually practicing law in Nevada. Great place to practice criminal tax law, I would say. And a lot of people in Nevada who think that that because they're doing illegal activity, they don't have to pay tax. But that
That's
turns out, for
right.
those listening, that's not accurate. If it's illegal, you need to pay tax. Who knew? But the
Yes.
IRS does. And so he became chairman. I'd already left the Hill a couple of years and was practicing, and then he called me up and said, "Well, you need to come back here."
Oh,
And what, which was very kind. I mean, it's a great honor to work for Grassley, obviously,
yes.
and particularly to work for the chairman of the finance committee. So it was an offer that just was too great, and I was joyful to come back and did that for them about 8 years. And so yeah, but anyways, very long story. But that's how I ended up Grassley's doorstep, kind of again and again and again through it. And who knows? Maybe I'll go back someday. I don't know. He could easily outlast me. He just
Yes.
goes. He's amazing. Yeah. In fact, I thought of him the other day. I was watching the hearing. Is maybe a different
Mhm,
topic, Jane, but
mhm,
they had the Treasury Secretary, and this was before Judiciary. I'm sorry, yeah, before Finance Committee. I beg your pardon. So the Treasury Secretary nominee, I think Bassert's his name, was Trump's nominee was before them, and bless
mhm,
Grassley. His last question was, spending a minute saying, "Now let me tell you about the tax whistleblower program that I wrote," meaning he wrote,
mhm. Yes.
at the end of the day, and all the great things it's been accomplishing and doing. And I want to make certain, Mr. Secretary, that you're going to be supportive of this wonderful program. And I thought that the new secretary showed he wasn't born yesterday. I think his exact quote is, "We are in complete alignment, Mr. Senator Grassley," and I think that's a good response for any senator. I mean, any cabinet official, regardless of
Yes.
political party. Anytime Grassley is talking about whistleblowers, just to say, "Yes, sir," and I agree. And so I think that's a good start. Actually, like I said, the program's gotten more and more respect and gotten kind of its feet on the ground. And I think under good leadership there now. And it was heartening to see that. I think it's understandable that people would have. Be concerned and want to understand where things are. But it was great for Gracia to ask the question,
Oh, yeah.
obviously, and then nice to hear that response.
If he asked you to come back, Dean, would you?
Well, I
Is that a possibility? I
well, I
mean,
don't know. I
you've
think
worked
he's
with
got
him
two,
for
3
years.
years left. He's 92 now, I guess, and
Yeah, he's in his
he's in till
90s.
94. Yeah. I actually kidded him that, I was already putting out getting the website address Grassley 100 for it. So never say never, but I think he's got very good staff, far better and talented than me now working for him. And so I don't think that'll be in the cards, but it's great to talk to him and see him. And it's I would just say, as Jane, you and I both know, it's such a blessing for the National Whistleblower Center, for all the whistleblowers listening, and folks, that he remains, as I call him, the
Yes.
great patron saint of the whistleblowers. And
Yes.
it's really, regardless, for your listeners to understand, a political party. I mean, I know everyone's gotten so jaundiced and hard-eyed, but he gave. I can remember back Reagan grind about whistleblower issues, and he's given grind to the current, the Biden administration. But it's just a constant for him. It's just a North Star, and he'll, be
Mhm.
that way with Trump. He has a good relation with Trump, and I think that's good. But I think it's more of kind of an interesting thing. The respect goes the other way. I think Trump has, I think in part because of Grassley being so, so senior, and but also just Grassley's demeanor, that Trump is always, I find, been very responsive to Grassley and respectful. And I think they recognize that this whistleblower issue is hugely important to them. But I think, and Jane, you and I are talking about it. My real hope is that they more than just say, okay, we get it. Grassley loves it, and we'll just go along. I think this is a chance for them to embrace the whistleblower program, not just the tax whistleblower program, but all the whistleblower programs. If you're serious about government efficiency and
Yes.
utilizing resources, and kind of two things. Jane, you're smarter than I am on this, but there's one part of the, hey, can you believe we're wasting money on X, Y, Z? That's just crazy. That's for the birds.
Right.
But also, hey, how can I find the bad guys and go get them? Well, both of those you need the whistleblowers for. I mean, particularly in tax. What I always say is, and this is proven, this isn't just kind of happy talk. There was a TIGTA study, and I can send links to your folks, and we've written about it. TIGTA, I'm sorry, is the Treasury Inspector General for Tax, said yes, the cases that the IRS looks at that are whistleblower driven are much more efficient, both in terms of finding bad apples and then collecting more money and getting more money, because the IRS is, it's not perfect. It's more art than science of them finding out, well, who are we going to examine or who are we going to audit? And the whistleblowers, they don't bat 1,000 either, but they're much better at going after, here's the bad person and making the IRS's job easier. Here's the docs, here's the this, here you get it. Here's the chapter and verse roadmap of what's going on. And similarly, I know you and I, even though we've both been around Washington, I'm amazed every day still. I'll be like, geez, I never knew that was happening. I can't believe that they're doing this. I find this in tax, particularly. I heard about a scheme the other day, and I was like, wonders never cease. Something I had never heard, and I've got fellows I work with in the whistleblower stuff that are longtime IRS criminal investigators or former commissioners we work with and have years of experience. And we're just, the creativity of people is without bounds when there's mischief afoot. But so it's the same thing. There's, okay, I get it, with the Doge, and he's got the Tesla fella and what have you, looking at all this, Elon Musk. These are the folks that are going to be your Sherpas to finding, the outrages, the systemic problems and making it easier. So I really think it's a chance for the new administration to embrace it. Maybe going back to Grassley, we'll finally get what he's always asked for, is the Rose Garden picnic party for whistleblowers there. Maybe this is it. We'll see.
Yeah.
Fingers crossed. He's ever optimistic, and I guess
I know.
But I do say, in all candor with folks who are listening, because I got a lot of this from my clients who I represent in cases that, regardless of where you are politically, I get that and I understand that, but I wouldn't, presume a certain outcome because of where your politics are. I think that in some ways these programs are below the radar. I mean, they're not really waking up the first day, maybe they should be, but thinking about these programs, and they have kind of a bit of emotion on their own. But I think that there's no reason that they shouldn't be supportive. And again, Grassley, and there's like Wyden on tax, Senator Wyden, and other congressmen and senators have been good at adding to the voices. Obviously, I think the National Whistleblower Center is a terrific, important voice in this as well too, and does good work. So all that matters. I guess I just say I wouldn't kind of self-censor if I was a whistleblower, thinking, well, that's for the birds. They're not going to be interested in me. I wouldn't presume that because of the politics and because of the election results.
Oh, good. I do have a question. Let's say there's a civilian out there somewhere. I remember I had a case one time, and I was looking at somebody who's working for Goodyear, the tire company, and the bookkeeper coughed up to me that the owner had a second set of books. And so if you're just a normal person out there, you're in our listening audience, or you're just part of the general population, and you find something that screams, IRS possibility here, and there's obviously, like you said, awards here for whistleblowers, what are the first steps they should take to report something?
So, very good question. And I would say, I wouldn't say I regret this. I did. I'm happy to talk to folks as a courtesy. They can contact or email me, and I'll, there's no meter running. I'm happy to kind of give them the sense. And often I'll say, well, look, you can probably just file yourself, and here's how I do it. And I've written a lot about this on Forbes too, so I've tried to kind of give people a primer. But for folks listening now, let's go through it. So I think the way to think about a good filing is really 5 things. One, that it's current. It's current and ongoing, even better. But current, so current in tax speak really means for an individual, the last 3 or 4 years this has happened. For a corporation, a major corporation, probably more like 6 or 7 years, because after that, it's pretty long in the tooth. Yes, the IRS could, maybe extend the statute, but it's a big lift. They're really not going to want to hear, Jane, well, in 2012, these fellows, even if it's, boy, they were doing terrible, terrible things. It's just that dog just isn't going to hunt. So it's got to be, recent, current, and what have you is going to be a plus to the dollars. Now, they'll look at cases that are smaller. Now, the threshold between the mandatory and the discretionary, but they're good on the discretionary, is $2 million of tax involved. And again, you can get 15 to 30% of that. And I would say most attorneys that represent do contingency work, so that kind of factors into it too in terms of representation. I would say that I don't think that the service is uninterested. There's lots of cases that they will take and will pay out that are below that. But I think it's got to be proportional. What I mean by that is if it's like $1 million case, okay, sure. If it's a doctor who hasn't, and I should say there's one exception to this, the kind of current ongoing. If they haven't filed their taxes at all, or they have an undeclared account, then the statute never runs. So then they're going to be all interested about, oh yeah, they've never filed their taxes. Let's come on and meet Jesus. Yeah, I mean, they're going to be very interested in that. But in terms of proportionality, and you can imagine if you're coming in and saying, well, hey, I've got Exxon and they didn't pay $2 million on meals and entertainment, probably not going to be waking up. They got a lot to do with Exxon, a lot of audit. They're really not going to be wanting to hear about Exxon $2 million. But if it's a doctor who owes $2 million or a lawyer who owes $2 million, they could be interested in that. So that's what I mean kind of by proportional. I think for a big company, I think they're going to want to see tens of millions, if not hundreds of millions, to be typical. I think for a medium-sized company, certainly millions, if not, again, 10 million, 20, that's kind of going to get them waking up and interested in terms of what's going on. Third, they're going to want to know your credibility. That's going to matter a lot to them because they have limited resources. They're going to have to launch 1,000 ships on this. They want to know, are you credible? In other words, the way I always think of it is it's one thing to come and say, yes, I'm the vice president of the bank. Here's the thumb drive with all the pertinent information of all the clients with an illegal offshore account. Here you go. Wow, I'm all ears. I'm very interested in hearing what this is. As opposed to, you can imagine, well, the fellow was at the bar and he told me about this guy who's his cousin that's got a next door neighbor that drives a really fancy car, and I don't know how he affords it given his job. Really maybe not. Waking up, getting them that interested on it. Like I said, they don't expect you to be perfect. They don't expect you to be going from choir practice to the Boy Scouts meeting. They're perfectly understandable that you were in the room. You were, the wheelman. Can't be made off. That's a different journey you're going to take. But you can, we have folks that have, gotten sideways. I mean, very typical, James, you'll get somebody who did the transaction. In other words, hey, they told me I could buy this insurance policy and then that would work out and I wouldn't have to pay tax on it. And now I realize that's all wrong. And, I need to, come see the light. Very, very common what we have. The IRS is great, but that doesn't mean you won't have to pay the tax that you owe on the transaction. Probably they might look kinder on you on penalties and interest, but they won't keep you out of an award because of that. So they want to know your credibility. Again, common. We have a CPA. They will listen to attorneys. What do we have to deal with attorney-client privileges? But a lot of times our attorneys aren't an attorney in the transaction, so that can work around as well too. But you got to navigate that. But they want to know your credibility. Fourth, documents are great. They love documents. So if sometimes it ends up we have to point them to documents because a lot of times people leave and then they decide to dime them out. But they, of course, left all the documents back at the filing drawer and everything. And that's life in the big city. And I would just say as a general rule that sometimes people will sign non-disclosures or have other things. As a general rule, we'll talk to you about that. But Jane, this pretty high threshold to bar somebody from coming to the government to talk about an illegal activity. Very government, I guess what I'd say is you'll find that even non-disclosures usually have an out for that because the SEC particularly has really come after companies that try to do that. So, again, don't let that self-censor. If you're like, well, I signed a non-disclosure, I signed, this. Let a lawyer look at it. Again, I'm happy to look at. We look at a lot of them. Pretty rare that we feel that they're not in a position that they can't come forward and talk about illegal stuff. The last thing, even though I said that you don't have to show bad heart, you just have to show they owe tax. Life is human nature in that for the IRS, understanding that these people are evil. And there's the example I give is it's one thing to say, well, they claim they donated a Picasso. They say it's worth 10 million, but it's really worth 8 million. Particularly valuation issues for the IRS are kind of a joy without end. They prefer, obviously a fact pattern of, yes, they claim they donated Picasso. There is no Picasso. There is no museum.
Oh.
They just like, okay, well, great. Let's hear all that. But that's, kind of someone that, they knowingly engaged in it. They actively, sought to evade tax. I think it's just natural that the IRS wakes up, in part because more penalties then come in play and everything like that. And it's just a bigger deal. And then that's kind of the 1.0. And then part of the filing, and we could talk about the court case that just came out the other day, which was kind of a mixed bag. It's making sure you're covering the waterfront of what you're filing, who's involved, what are the actions, what do the taxpayer do? A lot of that to try to put yourself in it. At the end of the day, you're trying to make the IRS work as easy as possible and get them interested in the case. So it's more of an art than a science, the filing. And so to be specific, what you need is it's a Form 211 that you file. That's just 2 pages. And they made it better. The Whistleblower Office has approved that just here recently. But then there's a narrative that goes with it. And quite frankly, Jane, part of the balancing is the narrative, because you can't give them War and Peace. This is kind of the problem. They're never going to read War and Peace. You've got to give it, like I say, it's kind of 10, 20 pages, maybe with a legal analysis explaining why there's a tax issue, what the tax issue is. Some of them are self-evident. They didn't pay their tax, but it can get complicated quickly of, okay, make it clear, make it straightforward that there's no doubt of this is why they don't owe tax. Strangely enough, one of the things that the IRS constantly complains about is it's not clear who the taxpayer is. So you'll see with us, it's like, here's the taxpayer. This is their address. This is their, this is where they are. This is what their tax issue is. And pretty, kind of a grab you elevator speech of this is the tax issue. This is the amount. These are the years. This is, so at least in the first paragraph, they're like, okay, I get it. But then explaining in the narrative enough that they get it and there's enough detail on it. And then explaining your documents and perhaps where other documents are that you don't have and who else they could talk to, kind of giving them a roadmap to do it. But that's still the challenge because you can't pour out, say 20 years of working there, 5 years of working there, what have you, in this document, because they're never going to read it. And they will interview, but you are trying to get them enough that not only they get it, but that when the field gets it, that there's enough detail that they're like, okay, these people know what they're talking about. They're anticipating our questions. And that's where it's sometimes very helpful for us. Like I said, there's a colleague of mine I work with who's a former top criminal investigator for the IRS. And so he kind of really knows, some of the magic words to say and punch and facts to say, look, let's make sure they understand that this is a fact, and away they go. So, but that's the quick and dirty of kind of what makes a good filing, what you want to have in the filing, and it's that narrative that's ultimately the key part. The form is it's gotten better, but is kind of just tertiary. It's really just to make certain, okay, we've got the basics here of who is this, who's telling us this, what are they telling us about, but then it's the narrative that's the key part to getting it, and away you go. So that's basically it, and they're open to it, but I'm not trying to kind of make special pleadings for talking to the lawyers, but the trick is to get the IRS interested and engaged in moving forward. And it's not to say I bat 1,000 or anyone would, but when you look at their annual report, and it's useful, it's right on their website, you can get it. There's a lot of filings, but the winnowing down is enormous. In other words, I'd say out of every, maybe it's 100 filings, maybe a handful get looked at and sent to the field. and then and even narrow after that, ultimately result in collective. Because that's kind of one of the sad things is the IRS in due diligence could look at it, could view it as valid, but then find that, well, that just isn't going to go. In some cases, they're already all over it, but in some cases, well, they're bankrupted, they don't have funds, or there's some other reason that is that could very well be valid. I don't want to suggest that but there's just reasons why it won't go. So it's the challenge is to get them to take the hard look, and then to take action. So that's why the initial filing is so important, just because we get them. You're right, because of our background and good work in this area, Jane. We'll get lots of kind of what I call cleanup on aisle 9. Things have gone south. They've gotten rejected. Once they're rejected, it can be very difficult to bring it back. Resurrections are not easy. Sometimes we'll find that, wow, they really did kind of miss the ball on this. Or, we'll look at the filing and say, well, geez, you didn't do this. But sometimes the filings will be a perfectly good filing, and you will kind of be head scratched. So, well, what is going on here? Maybe we can try something else. But once enough time's gone, it goes back to this timing issue. It's already maybe 2 years down the line. It's just hard, just human nature for any agency. Well, we looked at this, we looked at it. We really don't want to look at it again, kind of a thing. So that's where you kind of get one bite at the apple, and it's where I'll leave you with one last thought too. Is I can't tell you early on how many times folks would say, "Well, yes, I had the killer email that said, geez, it's all illegal, but let's do it anyways." But I was waiting for them to call me. Then I was going to show them that. I'm like, yeah, don't do that. You need to put on your best prom dress when you're going to see them. Don't leave anything behind. You got to come in all made up, hair, makeup, prom dress, everything for it. Don't expect that. Well, they'll call and then I'll explain this all to them. That call will never come.
Gotcha. Wise advice. Wise advice. Are you sitting on a mushroom by any chance? You are such a sage. Yeah, a sage. Or top of a mountain, maybe I should say. You're sitting on top of
I'm reading Alice in Wonderland, one of my daughters right now.
Yes, you are a sage. So I think we need to mention a act that you're hoping gets across the line. Can you tell us about that? Hi, we'll be right back with more of Whistleblower of the Week after a quick message from one of our whistleblower friends. Don't go anywhere.
Hi, this is Austin Handel, known on social media as Officer Ash, but also known as the Dunwoody Whistleblower, and the Vice Chair of the Lamplighter Project. The Whistleblower News Network strives to be the best source of information on important whistleblower stories. In addition to in-depth interviews with whistleblowers, Whistleblower News Network provides timely coverage of breaking whistleblower news, detailed analysis of whistleblower legislation, court cases, and exclusive investigative reporting on government whistleblower programs. Subscribe to the Whistleblower News Network to stay up to date on all things whistleblowers.
Right. Yeah. And I'll tie that into the court case I kind of alluded to, too, if that's right. We talk about that, too, for your listeners here. So the Whistleblower Improvement Act, Tax Whistleblower, IRS Whistleblower Improvement Act, the National Whistleblower Center has been terrific on this, really championing it to get it out there and get it passed. Not a shock, Senator Grassley is the great horse to try to get this through, along with Senator Wyden. And then in the House side, we had the chairman and ranking of the tax committees there as well, too, and they've been terrific on it as well. And the bill does kind of 5 things. One is it requires that the whistleblower, they have review in the tax court, but it's what we call a review that's standard is arbitrary and capricious as opposed to de novo. This is all kind of a lot of maybe fairly glazing eyes for your listeners, but it matters hugely in law. There's arbitrary capricious is a very hard standard for a whistleblower to prove. It as kind of it implies, it says, I have to win. I have to show that the government basically was kind of reckless, arbitrary and capricious. Really, they just kind of blew it from Sunday to Sunday in terms of what they're doing. It's very hard to prove that of an agency that they've done it. You can argue the law, that they applied the law improperly, they read the law improperly. That is a standard that's cleaner. But to just fight on the facts, and a lot of these cases go on the facts, it's difficult. And I've gone into tax court, and we've won for whistleblowers on the law, but it's been difficult. They've actually, anyways, they've kind of changed the standard the court has, how they've looked at this. But so what we're trying to do, de novo, again, kind of a Latin phrase, but really what it is what we all are used to on TV, of the judges there and the jury's there, here to be a judge only, but they're looking at the facts again, they're listening to witnesses, they're considering it and saying, I'm not buying that. I think that just isn't ringing true to me. I think this is what the standard is. And it allows a lot more give and take, where it's more of a jump ball, I guess. I mean, the agency still has some differences, but basically you have a much more fighting chance to say, hey, here's where we are. And in terms of discovery, you can get someone in the stand and say, well, now, wait a minute, you take me through this. So that's a big thing. And we thought that was it. And the court surprised us by saying, when we said review, they then viewed it as being this much higher standard. The Lisek case, which is the case I'm going to talk about here, we were hoping that they would reverse that. And the National Whistleblower Center, Steve Cohn and I did a long amicus brief. There was another amicus brief written by the Castellanos law firm, by two very capable lawyers there, Brian Willey and Usman Mohammed. They wrote a brief as well, too. And then there's obviously the attorneys that represented the person themselves. There was Erica Brady and Greg Lenman and Scott Knott, all capable folks. But the amicus briefs that we did and that the Castellanos firm did were just on this one issue of the standard review. Unfortunately, the D.C. Circuit got around that. Judges like to find reasons why they don't have to rule on something, and they essentially said, well, we don't need to rule on that because of the way we've made this decision. So we unfortunately didn't get a ruling at all on that. It was kind of, I always think of this case being kind of no news, bad news, and good news. The no news part was that piece of it. But back to the change of law, the de novo standard's a big one we're trying to get. And this is common for Grassley. It's just what we find is reality on the False Claims Act. As you know, Jane, it feels like every 4 years Grassley's got another amendment to the False Claims Act. He's got to update and improve it, because the courts have been better on the IRS law. We actually gotten some good decisions. But in the False Claims Act, I think it's been, in general, kind of a rougher road where they've really read it narrowly at times. And so he's had to constantly go back and improve and clarify and everything. He did do it once, or actually a couple of times with the tax one as well, too. But so it's asking to do that. It's asking that interest run if we're not getting paid. So right now, I'd be honest with you, when we did the law, this is a good example where it kind of bit us a little bit, Jane. In the False Claims Act, it gets settled, the person agrees, yep, we screwed it up, and immediately, here's your check for $50 million, and immediately the relators get their share, the whistleblowers, and it all kind of happens bang bang. In tax, because the taxpayer will give his check over to the Treasury, but then he's got his rights to appeal, but then there's a period of time where they're reviewing it internally with the IRS. And it can be, years. I mean, it's not untypical to be 6, 7, 8, 9, 10 years for an award to be paid. So be aware of that. It's not paying for next month's rent. It's a long struggle. And some of that's perfectly legitimate. You do, the taxpayer's got to be examined. The taxpayer has their rights. That I get. But even after that, it's not built for speed. And so we didn't anticipate that when we wrote it. Probably should have, but we didn't, because we had the model of the False Claims Act. Now it'll say, look, okay, IRS, you can dilly-dally and delay, but interest is running while that's happening. And I think just human nature, that'll get the IRS to put some giddy up in their step of going forward. So that's a nice change. Some treatment of attorney's fees for the discretionary program in the tax are not deductible for the whistleblower. It's a little bit more complicated, but that's the rough already. For the mandatory awards, they are deductible, so a better deal for that. And we again, it was kind of a drafting, which I blame myself on, that we didn't have that clear that it would be for both. So that's a technical one that we put in there as well too. So kind of some things that are a little bit more cleanup on aisle 9 for it, but they are important. In terms of it. And then also right now the awards are subject to a sequester. So they get kind of a haircut of 5.8% as part of a sequester across government spending. And this is to exempt that. So we'd like to see all those in. We're hopeful that in the big tax bill that'll be moving with the new administration that they can be included. It's a small provision, and just like we quite frankly got the first provision in 2006 for Grassley, kind of can float along with the rest of the garbage, which is common for these provisions that they just, as I said earlier, they just float along. So we're hopeful. It's got good bipartisan support, bicameral support, so we're hopeful on that. But just to turn to the LISAC decision, what was bad news about the LISAC decision was the good news was, talk about the good news first, is that the court narrowed this earlier decision called the Lee, L-I decision, Lee, of when a whistleblower could even go to court. And the IRS, not a shock, was trying to make it broad as the ocean of you can't go into court unless A, B, C are met. And kind of a nutshell for your listeners, the appellate court, I thought, did it exactly right. Said, no, look, it's one thing if the whistleblower submitted to the IRS and it never even got out of the blocks, then yeah, they can't go to tax court, because you'll get a lot of folks who go to tax court saying, well, yes, I was denied right out of the blocks and never went to the field, but doggone it, they should do something about it. The court, just to be clear for your listeners, they will not force the IRS to take an examination or do an examination. It's what it really gets into is, well, yes, there's the classic reason we're in tax court is, yes, go back to the three reasons you get paid. You gave information, they took action based on that information, and there was collected proceeds. It's really that middle piece is kind of, and as with LISAC, is the bridge. The collected proceeds, usually you can figure out pretty quickly, did they get money or not? And if they did it, there's nothing to fight about. It's like bald men fighting over a comb. There's no point to it. So you get that, but this says no. If they send it to the field, essentially that's good enough. You can go into court. So that was friendly, and that'll help a number of cases that are in court now. Is more friendly. But again, to make your listeners aware, it's not a passport to say, all right, let's stick the IRS and tell them they need to go audit this. The court will reject that out of hand. But it's the third piece that was disappointing. When we wrote the statute, we really tried to have it be sweeping. And when you look at it, there's lots of phrases like any administrative action, if they take any related action. We were really very worried about the service because of the experience of the False Claims Act, that there was a wonderful case, I think it was a DC circuit case, it was General Electric, where the court observed that they found it interesting how, while the agencies were always happy to hear from the whistleblowers, when it came to paying an award, suddenly they kind of forgot about the whistleblowers and all they had done for them. And so and I would say, in all candor, the IRS is better than that. They're good at the percentages of awards. The average award is actually about 26%, which is robust compared to like the DOJ and false claims, which is more like 15%. So a lot of things they do good. But when it comes to giving the whistleblower credit for related actions and for what it encompasses, that can get troubling. And it can also get troubling. That's where it goes back to your filing. Even your original filing is being much more encompassing and sweeping up. Look, here's all the things I think that taxpayer is doing that are wrong. Here's all the parties that I think are involved in this. Even though they'll give you some of that, I feel again, because they come to me afterwards, I always say, geez, I wish you had mentioned these five. We knew about them. It's like, boy, if you had mentioned all five of them, that would sure make my life a lot easier right now to say, well, there he is, Judge. We told him about Betty Sue. Betty Sue's right there. How could you get the idea? I mean, and so that's where it's, again, kind of an art, not a science. The pleading is to try to be encompassing of what happened. But that the court, now I would say that the facts in this case were bad. That's what kind of worried me about it, is that the person came in and was a medium-sized company, but they said, well, they're doing XYZ wrong over here, say it be Mills and Entertainment. And they did look at that and they investigated and they said, well, we're not really seeing that, but here's this issue regarding bad debt over here. And the problem is they really were they weren't like this. They were poles apart and made the comment that in their own observations that they were unrelated. And the court picked that up. I think, and there's a number of cases that are working their way through where it's much more this. They're much more kissing cousins. But the difficulty is we have kind of this case on this issue that's unhelpful. I think that there's things that we can still point to, but I think it'll be this factual fight to say, look, these aren't unrelated; they are related. This was a natural progression. A followed B followed C. It's peas and carrots there together. You get the idea. It's making it easier as opposed to if they had just said, well, yes, because they had, one point I should have mentioned is they admitted that they had audited this taxpayer because of the whistleblower. Said yes, we would never have gone to this taxpayer but for the whistleblower. But
Right.
his issue was wholly different on it. I would just say, as a pleading, it used to be that the IRS would pay you an amount, even if all you did was tell them about it. Now they'd pay them a smaller amount. And I wish they would consider that to say, well, maybe we're not going to pay you 15% or 15 or 30, but maybe we, under the discretionary program, could at least pay you, 5%, 3%, whatever it's worth. Because again, it's what we talked about. Just finding a taxpayer that's done bad things is not easy for the IRS. They did a big, under the I want to say current, but we're just coming. I don't know when this will be broadcast, but we're just now coming to the new administration coming in. The Biden administration had made a lot of noise about, well, we're going to go after very wealthy people and get after them and what have you. And they did that to a certain degree. And then Tigda, the Treasury Inspector General, came out and said, well, that didn't really get us very far. There were just so many, this is kind of tax speak now, no change rates, meaning that they went in there was no change. Well, that's a huge waste of IRS resources. And they're very, what a shock is they're most experienced, capable agents doing those exams because the wealthier, they're complicated. They're
Oh,
they're
yeah.
different than you and me, Jane. They have more money and they have complicated returns, and so you need folks that really got sharp pencils doing that. And so of all the folks you really want to make certain are time effective, and often it's tied into a partnership or layered partnerships. You get the idea.
Right.
And so I think even that, and the court I think didn't maybe quite appreciate there's value into that. And we had used this sweeping language, but anyways, it is what it is. I think that's unfortunate. We'll see. Congress may revisit that. I think probably not in this go around, just because this bill's been out there for a while and they've kind of got it already vetted and comfortable with it. And I think to put in something new at this late hour would be a little bit rough, but we'll see. And we'll see too how the IRS and the courts respond when they get these much closer in line of saying, well, wait a minute, I told you about this, and that naturally led you to this, and whatever. But
Right.
we're also, quite frankly, the standard review will help us is to explore more of those questions. Say, well, no, wait a minute, I want to talk to the examiner. I want to hear from him. How did you do this? Well, I was looking at that issue, and then, lo and behold, I saw that you get the idea that it led to B, that led to C. I think we'll do it. So that's the case that we just got. That it was a case kind of ended up being a bit of a damp squib. We were hoping for better news, but it's good news on the issue of jurisdiction, a pass on, unfortunately, on tax court standard review, and then like I said, really not the news we were hoping for on this issue of related action. But overall, I think it's good days ahead for the program. It's gotten
Good.
support from the commissioners, and I'm sure certainly with Grassley continuing to beat the drums for it, we'll be in a good place. But I do think culturally it's shifted that more and more people in tax now appreciate the program and the value it brings. So there's where we are. But go ahead. Once again,
No,
talk and
no.
talk and talk forever, as you know.
No,
This, but I
no,
want to
this
make
is
sure
this
we're
is
getting
great.
to your good questions. You
Oh
bet.
no, this is great. How did they respond to the fact that they would never have found what the subject did, even though it's ancillary,
Right.
without the whistleblower telling them? I mean, okay,
Yeah.
they didn't find what the whistleblower said, but they'd have never found the person.
Right.
If
I think the
how
court
did they
had a
respond to that?
yeah, the court had kind of a hobgoblin. I don't want to
Oh,
deprecate the court on it, but they had,
oh,
I think,
no,
kind
go
of a
ahead.
hobgoblin theory. Well, no, I may be in front of them. I
That's
don't
right.
nothing but sweet nothings, and that
Yes.
they're not only handsome but pretty as well too.
Yes, yes.
But I think their reasoning would go like this: of just saying,
Okay.
well, what we don't want is some whistleblower filing claims on Exxon and Mobil, and because they're audited every year, and IBM,
Oh,
and just saying, as they said, fly spec, just kind of throw something out there and say, oh well, this is me, you win against them. I think you could kind of separate that out, but I think they had that as a concern, and they could point to the statute and say, well, look, and really what they were doing. This is where it got interesting, because it actually got into Loper Bright, which is the Supreme Court case that came out that knocked down Chevron, which in some ways is a godsend for whistleblowers in a lot of ways. That and not just here, but regulations in general written by agencies have not been that whistleblower friendly sometimes, but in general not the greatest thing. So Loper Bright, in a sense, said no more deference to the agency and its regulations. And this case, this LISAC case, was actually sent back by the Supreme Court. It didn't make any opine, but it just said, go see our LISAC case to look at it. And then what the court did was said, well, yes, we're not going to give Loper Bright, we're not going to give Chevron deference because Loper Bright has told us we can't do that. But there's another deference that we can give called Skidmore deference. All these lawyers and all their terms. Skidmore deference, I kind of view as a little bit of a crutch. It says, well, we can at least be informed and take into consideration the agency's interpretation and regs, given their expertise and knowledge. And I thought, our dear friend Steve Cohn had it right in his quote on this. Again, you might give a link to the folks listening to the NWC press release we did on this. It's got his quote. It's saying my words, not exactly Steve's words, because I'm sure he would say it kinder and gentler than this. But basically said, well, look, wait a minute. When it comes to government agencies, I think really kind of writ large, and IRS too, they may be sweet and their mothers may love them, but when we're talking about knowledge of whistleblowers and award statutes and dealing with them, these agencies really don't have an expertise in this area. I mean, sure, IRS
right.
may have an expertise in tax, SEC may have an expertise in securities laws. The idea that these agencies have a wellspring of wisdom and knowledge on whistleblower award statutes, that just isn't the case. They may be trying to, or well-meaning, but unfortunately, they're just, you can shoot a cannon. You're not going to hit anybody at the IRS or SEC that's come from a whistleblower background of, oh yes, I
Right.
represent the whistleblowers, or I wrote those statutes. It's kind of a patchwork effort, and so that was, I think, dispiriting as well too. But to answer your question, I mean, the court could look at it and say, well, you've asked that it be that it be based, that the agency has taken, even if it says any administrative action based on the whistleblower's information. And yes, it relates to any related action. It was interesting that the court used the word any, which we had put in there again and again, and that the tax court is recognized as a very broadly written statute. They didn't really focus on the any in that piece. They talked about the use of the word any being broad in their analysis of the jurisdictional question, but then dropped that in the later point of any related action, which was disappointing, that they didn't say, okay, well, does this phrase any related action? They talk about related action, but not any related action. Does that inform us here? But the court's capable. I mean, I saw the reasoning on it, but it was like I said. I think what the court, and it gives us an opportunity, quite frankly, didn't really grapple with yes, this is an extreme case with them absolutely making a determination that it was wholly unrelated, and that there was, other phrases that, it was kind of my phrase, not the courts, but just, it was not even on the same, block or planet. Understandably, they only want to deal with the case in front of them, but it would have been nice that they had recognized, obviously you can have cases where there is more of a natural progression, that they are related, that it is the same taxpayer, and that's, we would view it this way. But courts don't like to opine on theoreticals or this or what have
Yeah.
you. So that was
Yeah.
unfortunate, but they'll get those cases. Like I said, I have cases now. I'm sure other attorneys have got cases now that they view as much more closer in link. And it's forced us to think harder about what facts we need to show. And I think it's important that the courts are going to need to let us have more leeway on the administrative record, because again, that's kind of part of the fight with de novo review and arbitrary capricious. It kind of limits the record, is to say, look, we need a better record here. We need to be able to interview people or get documents, because the agency itself hasn't considered this question related. We need to. So that's where we are, and the law will continue to evolve. But it was certainly on the not helpful part, that part of the decision. But again, it speaks also to how to file, and to be broader in terms of what you're filing matters as well too. So so we'll onward and upward every day.
And as for onward and upward, Dean, I hope I am loving every second of this. False Claim Act, okay? In settlements and judgments, it's exceeded $2.9 billion in fiscal year 2024. $2.9 billion. So the highest number of QTAM actions in history, there was 558 settlements and judgments in 24. The year before that, there was 566. I mean, whistleblowers filed 979 QTAM lawsuits, and it was the highest in a single year, right? So settlements and judgments since 1986, when, and of course you were involved in drafting this law, this legislation, when Congress substantially strengthened the Civil False Claims Act, there is now a total of $78 billion in recoveries and judgments. $78 billion. That is an amazing figure. But now I'm told, and that's why I'm so glad to have you, is the False Claims Act is considered under threat now because of legal challenges. Now, my question to you, and of course, potential legislative changes. My question to you is, why would anyone want to weaken the enforcement power of the False Claims Act?
Right.
Particularly the protections afforded to whistleblowers who report these fraudulent claims, and limit the ability to pursue these cases? This is just crazy.
Right.
Can you tell us what is going on? And I can tell you what some of the challenges are. The weakening of the, I think it's called Center standard. But what is going on that they're attacking the False Claims Act?
Right. So you've got, I think one of the things is in the design. Again, I don't want to chalk it up to cleverness on our part. Because the False Claims Act involves actual litigation, the companies involved, say, take like the pharmaceutical industry, they're quite familiar that they're under the gun of a whistleblower, that they're being subjected to pain, grind, and misery because of a whistleblower. Tax, SEC, because there's never an acknowledgement there's a whistleblower and there's no lawsuit, nor just an IRS exam as far as they know. Well, they can rail against the IRS, but they're not as kind of tip of the spear thinking, well, those son of a gun whistleblowers, I got to fix their little red wagons. They may suggest it, but I would just say still in tax, unlike in the False Claims Act, it's very rare that we even get a hint that someone, because we'll still have whistleblowers that still work for the company, that there's a sense of it. And it's kind of more of a rumor, or, I bet, or, something like that. But it just isn't part of the DNA. They don't know. So the companies themselves are not that worked up about it. So you've got, some industries that have really been put through their paces by the False Claims Act. It's interesting, some like the pharmaceutical industry has really gotten, seen a lot of challenges in their efforts because of it. And I think those kind of continue on. As opposed to the defense industry really reformed itself because of the False Claims Act. My understanding is, I've seen a couple papers where they really, cleaned up their work, and maybe the pharmaceutical industry is doing some of that too. I'm not as familiar with them, but I know they've been been getting grinded for a long time under it. But so you've got, I guess, kind of answer your question, you've got a lot of folks who really don't like it, and they know they don't like it. And so that gets, the Chamber of Commerce and other people really waking up in the morning, doing it, and thinking it. And then you've got folks, we'll take them at good faith. There's a core of it of just, well, can someone, what you're having with key tam and whatever is just a long legal phrase that basically stands for suing on behalf of the king. You're suing, you're in the feet of the government, stepping into the shoes of the government. There's the phrase. And is that allowable? This is what Justice Thomas had kind of raised, and other folks have said. Are we comfortable that you can allow somebody to step into the shoes of the government and sue? So you've got those legal challenges, and you're right. You've always got a challenge of X, Y, Z, and I'm sure you'll have other speakers who will come on and other podcasts that can give you a chapter and verse on this. But you're right. There'll be this aspect or that aspect of. Well, does it count if it's overseas? Does it count if it's this? There always seems to be some new wrinkle that's out there, and the courts, in general, even tend to just read it narrowly because there's a skepticism. And again, that's something that happily, both with the SEC, CFTC, and IRS ones, we just haven't had to face because we're not in court on behalf of the government. We're behind the government. We don't face that there, but you're right. For the False Claims Act, it's there, and that's why I think the work of the NWC, and I'm happy to serve as an advisor to the NWC, but I say for your listeners, I don't get a penny from them, and I don't want a penny from them. But I will get this advertisement. I think it's where the NWC's work and your work, Jane, and everyone there matters so much is educating and informing, all the members of Congress, because, Grassley won't be with us forever, even though it'd be nice. And he needs allies too. And I think that's one of the challenges, getting strong allies for him, because I do think sometimes folks are just kind of waiting and have been shocked. I think a lot of people have retired waiting for Grassley to go away, but are, thinking, well, once he's gone, then, boy, it's going to be a different day. So we really need to get more and more strong allies and advocates for the False Claims Act. Because I fear too much. What I kind of saw there is that a lot of members on both sides of the aisle would be pretty good on it, but kind of were, well, after you, Grassley. Well, sure, I'll sign on whatever Grassley signed. Like, well, Grassley doesn't need to. I can tell you, Grassley is actually a very modest kind of person. I mean, he's happy. I know he the other day was singing the praises of the False Claims Act, talking about how great it is. But I know he'd be thrilled to have other members saying, well, Chuck, why don't you hold the cape this time? We'll get out there and get the hallelujah, praise the Lord. Well, we're right. I'll be thrilled to have other people carrying the baton. And so we need more of that, and seeing that. And in some ways, members may say, well, Grassley's got it and I don't need to. So we'll see. But I think the work of the NWC matters hugely in this area. And just quite frankly, for your listeners, to tell their elected officials, it matters hugely for them to hear, hey, I really care about this. It really matters to me on this. But I think, and I would just say every administration, it's always kind of a little bit, how are they going to do? But I think, the incoming administration knows it's important to Grassley. So I'm hopeful there. And it really goes to your point, though, Jane. It always is kind of a head scratcher of, tell me again, this program's been the sun and the moon, what's going on? But, there's no story's perfect. I mean, I'm sure there's this person, got sued and that was all, plenty of nothing. And there was no, I'm sure there's some imperfections in it that fair enough. But it's kind of balancing that with, all right, tell me about the program overall and what can we do to address, fair concerns. So, it'll continue on. But I think there's more and more of a realization, and I think what someone has to, here's a real story. It goes back to the Doge and this effort to do government efficiency, and I think there's more and more of a growing realization we're going to start to face. Where are we on the budget? Where are we on the deficit? Well, tell me again, what we're going to get rid of this program, because you mentioned the money's coming in, but there was just a study that came out. And I think NWC highlighted it. I know I brought it to their attention out of New York, just the New York state tax key 10 that we talked about earlier, that it is the effect, it's the bank shot that matters as well, to the ripple effect, if you will, of whistleblowers that matters hugely. It's not just the direct, oh yeah, we told you about, person X, and by God, he's going to, get right with the Lord. It's that indirect effect that makes the False Claims Act even more important. But this tax one, and I'm going to butcher the numbers. I apologize, and hopefully you can put it up there, and they can read the study and get the exact one, or just the press release from the NWC will do it. I want to say it was like 6-1 the indirect impact, because particularly in tax, here's the mindset of folks that are up to real moonshine and scofflaws. Is they're thinking, well, I got a smart lawyer or accountant, and I'm a smart guy, and I've just got to get it past those those folks over at the IRS, and they're for the birds, and I'm gonna that's gonna be easy peasy. And I think that's wrong. I think there's very capable people at the IRS, but I get it. And, and they'll purposely say, well, we're not going to report this, or we're not going to tell them about this. It makes it tough for the IRS to do it. Well, your calculation of getting one by is wholly different when, think if you're going to set up an illegal undeclared account in Switzerland, to think, well, okay, I got to trust my banker. I've got to trust his secretary. I've got to trust, this
Right.
person. You get the idea. Suddenly I've got 5 or 6 other people that not one of them is going to take a thumb drive down to the IRS, put a stamp on it, and send it to them. You get the idea. I mean, suddenly it's a much bigger world of folks that could dime me out. And we've gotten
Right.
thousands of people had to come in because of Brad Birkenfeld and whistleblowers
Right.
coming in on switch. It just, but I don't think that's still in the DNA of tax mischief, in that folks are really thinking that through yet. But it's not. But going back to your point about the False Claims Act, it's not only the direct impact; the indirect impact is so significant. And so I think to be serious about, well, you bet. Let's get serious about the tax, about the debt, the deficit. You're exactly right, Jane, to say, well, yeah, let me tell you this great idea I've got. Let's pull the rug out on one of our most effective, really our most effective program going after fraud. Is this? I mean, it's the internal folks. They know where the fraud is. They know where things are going on. And you know that chapter and verse, Jane, and from all of your great interviews and work you've done, those are the folks you need talking, because otherwise you'll just never find it. So I'm hopeful
Exactly.
that it'll stay in place. But you're right. There's always challenges, but I'm hopeful we'll keep them at bay.
So, Dean, and I hate to take as much time as I can. This is just golden. It's just like I found a gold mine and we're just mining all this gold. But can you rip the curtains back on who's behind these legislative attempts to narrow the False Claim Act application, and increase judicial scrutiny, restrictions on whistleblower protections, weakening of this entire standard? Rip that curtain aside. Who is behind this? Is it the Chamber
It's
of Commerce? Is
Yeah,
it
and I think they've been open about it.
oligarchs?
Yeah,
Is it
the oligarchs. I don't think they
politicians?
really care about. I have the feeling that the billionaires just kind of go about their business. But anyway, and I don't think there's a hide for your readers. I think they've raised money. I don't think they're hiding it. I mean, they believe they've got a principled view of doing it. So I don't. I think if you go to their website, they'll be happy to tell you all their efforts to I think they would probably phrase it as we're trying to curtail or limit or deal with abuses, however they phrase it on it. But I think the chamber is the primary one. There's an entire bar that does defense work. I think for them, it's a little bit of a mixed bag, because on the other hand, if you're so successful, then you're going to get yourself out of work because there's a lot of lawyers that defend this stuff. But there's always more work out there. But I think that's it. I mean, I think that's what other guests you'll have on will probably be able to expand on that. And I do think you've got some lawyers, and while I think of Clarence Thomas, there could be folks all over the political spectrum. I'm not as sharp on this, to be honest, but just say, well, look, I am troubled that you can be in the shoes of the government suing, and I think that should be narrowly read and narrowly interpreted, because we get. We get bad decisions, not just from judges that have, this label or appointed by this president or that president. It can kind of come at us through different ways and different folks. And I take it hard, what the judge, it is a different world that we allow. It's a very long legal tradition. Like I said, it goes back to England, hundreds of years. It goes back to Lincoln years and years ago. So I think that's it. But it's a good question, and I'll see if we can't get some more resources for your website of other folks. There may be other groups that do it, but again, I'm not trying to cast them as the devil. They've got their reasons, but like I said, I don't think they've been shy about it. I think the chamber's been openly saying we've got problems with this and concerns about this, and have tried. But happily, they failed to date. But I don't think they're going away. I think they have kind of a long game. Very, very long game, to be honest. I mean, I think and that's something to be in mind. I think they've been trying for, good Lord, I think Grassley first got it passed in '86 to try to water it down. But Grassley's been able to get reforms through, and other members supporting him that have strengthened it. Yeah, so I'm hopeful on it. But well, Jane, I think I've exhausted your audience,
No,
of all things that could be
no, this
possibly talked
this has
about.
been wonderful, and we'd like to get your closing statements.
I think for the whistleblowers listening or considering it, I think there's possibilities there. I think don't be put off by, well, I'm worried about this, worried by that. Call me. There's other attorneys out there that do fine work. Talk to them. See what makes sense and everything. But it's really hats off to the whistleblowers and those listening, because I'm in awe of them. They put a lot on the line. It's not an easy task. It takes a lot of patience, a lot of time. It's not an easy journey. It can be frustrating. It's not all sunshine and roses.
No.
Getting through all this, as you well know. So it's really, hats off to them. But you're right, Jane. At the core of it, there's lots of protections. Actually, thanks to, again, Steve and the National Whistleblower Center champion, there's protections for tax whistleblowers that Senator Grassley and Chairman Wyden got in.
Let's not forget you, Dean. Don't be humble.
Yeah, well,
Please.
but they're all there, and so be mindful of that. But so the government is wanting to reward you. They recognize that it's a lot that people are putting in the line, but again, particularly in tax, because the most informed taxpayers, whistleblowers, I beg you, often are the most well positioned. They are the vice president of tax at a company. They are somebody who's gone through a lot, and so the government recognizes that. I think as best they can, they try to be fair. I don't think they're trying to horseshoe. Sometimes it may not feel like that, but I think they're trying to, and the government has the programs to do that. So I think looking at it, and you're right, False Claims Act as well too is expansive, and then SEC and CFTC, and if you know about bribery overseas, there's kind of no end of different areas and possibilities. One interesting thing I should have ended with is all the money laundering, financial crimes get subsumed now under is actually a case that Steve Cohn and I worked on together, and one a very important case that then was codified into law that really broadens that it's not just tax, but it's tax, money laundering, financial crimes that the IRS investigates. All are covered by that. So it's a broad statute. So real possibilities. But Jane, thank you so much for having me
Thank you, Dean.
on today. I greatly appreciate the opportunity. It's always an honor to talk to you, Jane.
Always a pleasure. Can we have your contact information, Dean, before you go?
You bet. So I think probably the best way to do is just to email me. I check my emails all the time. It'd be D as in dog, Zerbe, Zerbe, at ZMF, Zebra Mary Frank, ZMFlaw.com. Is that, and I'll get back to you pretty quickly, and happy to answer any questions and see what I can do. And I think also another resource is the National Whistleblower Center. They've got a great referral there too, and always good to talk to them as well as a good source for information and what have you. And you bet.
Dean Zerbe, a hero. Thank you, Dean. Thank you for listening, and please don't forget to like, comment, and subscribe. If you want to read more whistleblower stories, go to www.whistleblowersblog.org. Music by Rachel Kilgore. Editing and booking by Anissa Sheikh and Victoria Thompson. And a special thanks to our sponsors, Whistleblower Network News.
Growing up, I think you'll find that it's just as hard to stand up tall as it was when you were small. The truth is hard.